many, is my name is Claire Harrison. I'm the Managing Director of Harrison's. We're a HR consulting business that was established back in 2009. Today is a quick 15-minute to give an overview of the changes to the casual path to permanency that came into effect under the Fair Work Act. A little bit about me. I'm not a lawyer. Therefore, I'm not giving legal advice, and nor am I giving any information that's specific to your situation. A bit about Harrison's. For those who don't know, we have a few different service areas. So consulting, which can be an ad hoc project, anything from a small business compliance package to a large org restructure, training, leadership coaching, workplace investigations, anything that a HR team would normally do, but maybe the team doesn't have capacity or capability to do that. Our HR team service, we explain as being our outsourced in-source service, and that's where we start with a HR health check, we develop a plan, we do an engagement survey, and then we have an allocated consultant who becomes your HR manager, who works with you on site or not as your HR manager to deliver on that plan over a 2-year period. Recruitment, I think, is self-explanatory. And My HR Experts is our online subscription service that's currently being revamped. So I'm excited to be relaunching that very soon. And I will move on from that. So let's just give a little refresh on the changes of the timelines to the Closing the Loophole Bill that came in with the Fair Work Act. Just letting some more people in for a little bit. So just that's the recap in terms of what they are. So, we're getting towards the tail end of them. But most significant for 2025 are the new rules and penalties around the underpayments that came in from the 1st of Jan with some significant penalties. From 26th of Feb, there have been some changes to the enterprise agreement model terms. And from 26th of August, the new right to disconnect from small businesses come in. Saying that, casual employment rules changed on the 26th of August 2024, but we have been under these transition periods, which they'll probably come into effect on 26th of February. We're going to talk more about what that looks like. Okay, so the new definition of casual, which did come into effect last year in February, did alter the definition under the Act. So it had two components. One is the employment relationship has no firm advance commitment to ongoing work, taking into account a number of factors. And secondly, is they're entitled to casual loading or a specific casual pay rate under an award, registered agreement or employment contract. So just to talk a little bit more about that firm advance commitment. So whether there is a firm advance commitment needs to be assessed on the real substance, practical reality and true nature of the employment relationship. So truly, is it casual? Does it have any firm advancement or not? So to talk more about that, several factors including whether the employer can offer or not offer work to the employee, and if that's happening or not. The employee can accept or reject work and whether that is happening in practicality. It's reasonably likely there will be future work available of the kind the employee usually performs in the employee's business based on the nature of the business. There are full-time or part-time employees performing the same kind of work in the employee's business as the work the casual employee usually performs. The employee has a regular pattern of work, even if it changes over time due to, for example, reasonable absences from injury, illness, or other reasons. So it's not a full list. There's other factors that may apply when looking at that no firm advance commitment. For this assessment, not all factors need to be satisfied, and a single factor will not determine whether a person can be considered casual or not. For example, a regular pattern of work, which we've spoken about for a long time, on its own does not indicate that an employee has a firm advance commitment to ongoing work. An employee who has a regular pattern of work may still be a casual employee if there is no firm advance commitment to ongoing work. When assessing whether there is a firm advance commitment of work, you can look at their employment contract or any variations to the employment contract, or any mutual understanding or expectation between the employer and the employee that isn't part of the contract. The mutual understanding or expectation can be worked out from how the contract is actually performed or what the employer and the employee do after entering the contract. So that's the new definition of casual that's been in place for a year now. So the two components, and that was a little bit more about that no firm advance commitment. Okay, that's an example, which I'm not going to go through. It's about the new definition. Okay, so we've got rid of the words casual conversion and we're moving on to employee choice pathway is the new terminology. So the new rules about, we'll say casual conversion, they changed, like I said, on the 26th of August 2024. The transitional arrangements have been in place since then. So transition arrangement ended a few days ago, 26th of Feb 2025, and for small businesses, it'll be the 26th of August 2025, so another 6 months or so. The new employee choice pathway to move from casual to permanent full-time or part-time is in effect now. So employers need to make, until, just to go back historically and look at what we used to do, which is now not going to be relevant, but just to recap it. So until 26th of Feb 2025, employers needed to make a written offer to convert a casual to a permanent employment within 21 days after a casual's 12-month anniversary, if the casual met these conditions that are outlined here. The offer of casual conversion had converted the employee full-time or part-time based on certain things. So that was now the old arrangement of casual conversion that we've had in place for quite some time, which has been in a mix of the Fair Work Act, it's been in the awards and different variations over the years. During the transitional period, casual employees employed before 26 August 2024 could make a request to convert to permanent employment based on that new amendment to the Act. So let's talk about the employee choice pathway the new way. So from 26th of August 24, casuals also had a new pathway to permanent employment under the National Employment Standards. This is referred to as the employee choice pathway. Under these rules, eligible casuals can notify their employer in writing of their intention to change to permanent employment. An employer can only not accept on particular grounds, which we'll cover. From 26th of Feb 2025, casual conversion will operate under an employee choice pathway, so which wholly replaces the old regime of casual conversion, dispensing with the need for an employer to instigate conversion to permanent employment. So some of you might have already looked at the awards around this. The awards have been already altered. So for example, under the Clerks Award, under clause 11.5, they've retitled it to be called Changes to Casual Employment Status, and it now refers to the National Employment Standard. So, so that is a change for us. So in terms of looking at the process, so first of all, talking about the making of a notice. So under the new pathway, a casual employee can give written notice to their employer to convert to permanent employment if they have been employed for at least 6 months and they believe they no longer meet the requirements of that new casual definition that we just discussed. For small business, like I've said, there's some more time. For that, as mentioned earlier, the new definition of casual employee introduced into the Fair Work Act by closing loopholes, number 2. An employment relationship is considered casual based on that firm advancement and the entitlement to casual loading. So that's the employee giving you notice that they're going to move to permanency based on their eligibility. So then you have a responsibility as the employer to respond. So before responding, the employer must consult with the employee. So this includes discussing certain details of what will change if the employer accepts the notice and the employee is no longer a casual employee. So this includes This includes whether the employee would be a full-time or part-time, what their hours of work would be, and when the change would take effect. So before responding, you have to do this consultation with the employee. You can't just rule it out. Consultation is part of this process. You have 21 days to respond. At that point in time, you either have to accept the change or not accept the change. So if you are accepting the change, then it needs to be a written response, and it must include information about the new employment status, for example, full-time or part-time, the new hours of work, days of work, when the change will take effect. Saying that, changes must take effect from the first day of the employee's first full pay period, starting after the employer gives their response, unless there's an agreement to another day. Otherwise, that's when it needs to start. So if you're not accepting the change, the written response must include the reasons for the decision. We're going to talk more about how to, if you are not accepting the change. So reasons for not accepting the change has definitely been tightened compared to what they were previously. So I'm just getting a message saying I'm lost. Can everyone hear me and see me? Thank you. Okay, so the only reasons that you're going to be able to refuse, to disagree, to not accept, if legitimately the employee still meets the definition of a casual employee based on what we discussed earlier in terms of what that casual definition is. There are fair and reasonable operational grounds for not accepting the notification, such as substantial changes would be required to the way work in the employee's business is organised. There would be significant impacts on the operation of the employee's business, or substantial changes to the employee's employment conditions would be necessary to ensure the employer does not break rules, such as under an award or an agreement that apply to that employee. So another is accepting the change would mean the employer won't comply with a recruitment or selection process that is required by law. So really important to get all of that right. So these are the only grounds that you can refuse the notice. It's not a request, it's a notice. So you need to be really clear that you, if you are refusing, that you legitimately fall under this area. I'm not going to go over the example timeframes. I just wanted to touch on the importance of the casual employment information sheet statement. So, and it has been around for a little while, but importantly, in terms of what it contains, you're probably all well aware of that. But in terms of providing it to employees, so obviously you need to provide it to all new casuals when they start with you. We would normally just issue it as part of the contract so that they have it. But it must also be provided to casual employees at the following times during the employment relationship. So for small business employees, after 12 months of employment, for other employees, after 6 and 12 months of employment, and then every 12 months of employment. So really important that you're doing that. Just to touch on a little bit about adverse action, so protections at work. So an employee can't take certain steps to avoid their obligations or an employee's rights to change to permanent employment. So that includes you doing these things to avoid basically the move from casual to permanency. So reducing, changing the patterns of work or terminating employment. That would be seen as adverse action, and there would be a claim that would have legitimacy there. Casual employees are also protected against adverse action by an employer because they have a workplace right, including their right to notify anything about, if they're telling their employer they no longer meet that casual definition, if they receive a written response from their employer in relation to their notice, if they participate in a dispute about changing the permanent employment. So please be very careful about how you're handling the notices of moving from casual to permanency. There is a mandatory framework to resolve casual conversion disputes. But what I would say is best practice would be for you to ensure that if there is an issue, a dispute within your organisation, that you have your own processes to be able to deal with that and quickly resolve that. But to talk more generally, so the options if the employer and employee simply cannot agree, where an employer and employee are unable to reach agreement as to whether permanent employment is appropriate and attempts to resolve the dispute at the workplace level are exhausted, the dispute can be escalated to the Fair Work Commission. While the Commission will initially seek to resolve the dispute by an informal means, the Commission can, like I've mentioned on the slide, can arbitrate the dispute and a binding decision can be made. That's why I say best to have your own processes internally to deal with it proactively to resolve those issues. So where to start? Like, really importantly is to make sure your contracts are really clear and meet the requirements of that casual definition. We see them very often, we see casual contracts that have notice periods in them. We see casual contracts sometimes with leave entitlements in them, and a whole raft of things that shouldn't be in there. There should also be very clearly stated the casual loading amount that the casual loading is being paid. So really important to get your casual contracts right. Check what's happening also in practice though, in terms of how your casuals are being treated. Are they being treated more like permanent full-time and part-time employees? The award and pay audit, that is to look at your casual rates, including their penalties and loadings, to make sure you have their award classifications right, their pay rates and their penalties. Consult with employees about the changes, any changes that you need to make. Make sure your policy and processes are in place. So policies, processes around that dispute process, but also get really clear in terms of how you're going to respond to those notifications of move to permanency. Regular audits, just to make sure what your contracts look like, but also what's happening in practice as well as your policies. Document everything, the notifications, your considerations, how you made your decisions, the consultations part of that. Keep all of those documents on file. And I have already talked about the importance of issuing the Fair Work Casual Employment Information Statement. In terms of how Harrisons can help, obviously happy to provide advice on any of these areas. We do have the Employee Choice Pathway Kit should you need it. It's a casual employment contract template, which could cover award or not award covered people, a template response to request if you're accepting it, a template for refusing. We have a casual employment compliance questionnaire. So should you want to take that up, there's an offer for today. The other thing we can definitely help with, and not just for casuals, is an award and pay audit. And, very important considering the changes that have already happened in January in terms of those underpayments, but just as important for the casuals. So that looks at what award are you covered by. We have so many, 90% of people we meet with for the first time say, we're not award covered because we pay people above the award, so much above the award. They will actually still be award covered, which means that you do need to comply with the terms of the award. There's ways to sort of get around that, but it doesn't take away the fact they are award covered. So doing that check on what's the award, what's their classification levels, and yes, based on what you are paying them, how does that meet those award entitlements, considering all of the entitlements for overtime, leave loading, penalties and everything else. And that needs to be documented if you're going to provide a salary, which can only be done under certain awards in certain ways, versus paying just as per the award. So we can definitely help with that as well. So that is my quick, I've already gone over 15-minute overview of the changes to casuals. If you want to drop me a note on LinkedIn or email and ask any other questions, happy to answer that. But good luck and get started on making those changes. I'm Claire Harrison. Goodbye. Have a great day.